Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item number 11.
After vacation.
Much obliged, Lordship.
Obliged, Your Lordship.
Lordship, I beg to mention item number 10. Mr. Upadhyay is there. I am praying if the matter can come up after vacation.
Lordship, here the convict has already served almost 2 years, so punishment is.
Please, Lordship. Also, I beg to mention item number 5, Lordship.
Five.
My Lord.
What's this matter about?
My Lord, may I kindly recall this is the matter relating to the service conditions of the staff of district courts.
Okay.
Shetty Commission report is there, which has not yet been implemented by the state. So we are seeking implementation of that, the recommendations of that commission through this writ petition.
But if you recall,
Yes, Yes,
I'm not so sure
Yes, madam.
whether the matter is still sub judice before the Supreme Court.
My Lord, that is the contention of the state, of the respondent state. It's been the contention for the last 2 years, but we are yet to understand what exactly is sub judice and whether this issue, Shetty Commission issue, is also sub judice. So on the last, quite a few months back, my Lord, state had submitted a bunch of papers to show pendency in the Supreme Court. I've gone through the papers, my mistake maybe, but I have not understood what is pending in the
If
Supreme Court.
I am also not acquainted with the matter.
Yes, madam.
But I'm made to understand that Supreme Court has passed certain directions way back about 4 or 5 years ago.
Yes, my Lord. My Lord is absolutely correct. In 2008 itself, Supreme Court had passed a series of directions, and the main direction would be for states to implement the Commission's recommendations.
Cities Commission.
Yes.
Then would that include recruitment process and all those things?
No, service conditions, my Lord.
Only service conditions.
Implementation of pay commission, etc.
I think uniform, cadre.
Yes,
kind of thing.
yes, my Lord. Yes, my Lord. So a whole host of recommendations were there. Supreme Court directed for implementation by all states, and more importantly, my Lord, in case there is non-compliance, non-implementation, high courts are to take up the issue, either on the administrative.
Why come before the single bench?
Because because it's a slightly unique situation, because what we are seeking is implementation of a commission's recommendations, which state is anyways duty bound to have automatically implemented. Going to the division bench, my Lord, I would say deprives us of one level of redressal. Supposing there is a.
See, what happens is, if it is a matter.
Yes, my Lord.
Again, you correct me if I'm wrong.
Yes, my Lord.
If it is a matter which is a direction by Supreme Court.
Yes, my Lord.
And High Courts to take up the matter.
Yes, my Lord.
More often than not.
My Lord.
The division would take, in fact, it should be by a bench headed by the Honorable Chief Justice. And then whatever direction the High Court takes up, if that is not implemented,
my Lord,
then you approach the Supreme Court again.
My Lord, Lordship is correct to the extent, I would humbly submit, my Lord, to the extent if the taking up by the High Court was in maybe a suo motu basis, then the Chief Justice, a bench headed by the Honorable Chief Justice, would be the more appropriate forum. But here, my lord, we have come for seeking mandamus, etc. For that, my lord, the single bench would be the more appropriate forum, my lord.
Any direction given to the state for implementation?
By Honorable Court, my lord? Not yet, my lord.
No, by the Supreme Court?
There is a direction from 2008 itself, in 2008.
That is there.
That is there.
Okay, so now the only question is whether they have implemented those directions or not.
The answer is no.
No.
Even they admit
so you have
no.
come.
They're giving certain reasons why not. But Lordship has to adjudicate whether those are tenable or not tenable reasons, my lord.
See, in matter of this kind, this court will be bound only by the direction of the Supreme Court, and to ensure that it is implemented, and that's it.
My lord, so in this matter, there's a similar matter which was pending before this Honorable High Court, and it was transferred to the Supreme Court, Lordship. So I have to look into this whether it's similar or, and if it's not similar, Lordship, then we'll. My lord, the Advocate General will argue this matter. Otherwise, we'll have to file a transfer petition in this matter also.
My lord, just to clarify, what my friend is referring to is a matter filed by the staff of the Honorable High Court, my lord. And that was for implementation of not the Shetty Commission recommendations, but for certain ministerial rules. I'm not very familiar with the matter, but for certain rules, implementation of certain rules. Now, I believe, subject to correction, a committee was set up to look into those aspects, and the committee is seized of the issue. So whether it's transferred to Supreme Court or not, I'm not sure. Could have been, but that is a completely different matter, standing on a different footing, my lord.
My lord, I have to examine this.
Definitely. Anyway, this will be a very, it'll be longish, if
True, my lord.
I may say so.
So if I can humbly suggest, my lord, if subject to Lordship's agreement, they've been taking time, they've been taking adjournments for quite some time. Very well, if today also they're asking for time, but a date may be fixed on which day they undertake to at least start these submissions, my lord. Because we are getting nowhere, my lord, in this matter, and interests of a lot of people are involved.
Yes, of course.
If not before the vacations, after the vacations also, but a fixed date, my lord.
My lord may have it after vacations, Lord. In the meantime, I'll look into it whether matter is.
What Mr. Jindal said is correct. If we put up this matter after vacation, then the same thing will happen. The moment vacation starts, you are still, going through the hangover of vacation, and then another month will go.
Either before vacations or after, my lord, a fixed date where my friend undertakes to start, my lord.
But you have not advanced your argument.
My lord.
Have you advanced your argument?
No, we haven't, but what's happened is that the pendency in the Supreme Court is the preliminary issue that they're raising. According to them, the same issue is pending in the Supreme Court.
Okay, yes.
So they have to satisfy Honorable Court whether the same issue is with the Supreme Court.
We'll take it up on 17th then.
Last day.
Let's see how it goes.
Very well. Very well. Very well.
On pre-made by parties, let's just matter on 17th.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 7. Your Lordship, I pray let this matter may come up after vacation, Your Lordship. No objection, Your Lordship.
On pre-made by the petitioner, let's just matter after vacation.
Highly obliged, Your Lordship.
Supplementary list, item number 1.
May it please Your Lordship. Your Lordship, we have tried to contact the concerned person with regards to the instructions, but we have not been able to contact him. I think he's out of station. So Your Lordship may kindly give us 1 week time, Your Lordship, to get the instructions.
what is required for you to, it's just for your that earlier communication.
My lord,
That is
the
just
last
to be-
Your
communication
Lordship,
which-
that
regarding
is to be
the
revised
My
or altered or whatever.
Your Lordship, regarding the clarification, we had called the concerned officer, but we have not been able to contact him. So kindly grant us 1 week, Your Lordship.
My lord, may fix it next week, my lord. Otherwise, 1 week, then it will go after vacation. So we need.
We'll fix it on 11th
Yes, Your Lordship.
on pre-made by the parties. This is matter on 11th.
Item number 2.
Pleases your Lordship.
Yes.
Lordship, CRP number 28, we're representing the State Department. I'm seeking a new accommodation adjournment in this matter because considering that the matter is pertaining the long pending old bills, the State Department is taking some time to take the decision. Let this matter come up after the vacation.
The last order would show that a decision is likely to be taken in a day or two.
But they're taking-
That was the
they
commitment
require
given
some
by them.
Yes.
We've spoken to
Let it
them.
be listed on 16th. We'll give it a try. Because according to my understanding, it is moving the file. Let it be
Requires
listed on 16th.
long old pending bills, so it will require some more time. If it could come out after vacations. Lordship.
Vacations would be too long. Well, let's have a try on the 16th. Otherwise, they'll sit over it. What's happening is the government is sitting over it.
You talk to your client.
Lordship.
Tell them to be serious in the matter. This cannot go on.
Yes, Your Lordship.
This court has given you ample time for you to decide. Sooner or later, you have to decide one way or the other.
Yes.
And it's better you make your decision now and get the matter over and done with. Otherwise, if it goes on like this, it's in limbo.
Yes,
The
Lordship.
court, has conceded to the prayer of the parties for an amicable settlement. If that is not forthcoming, then it's pointless to keep this matter hanging. Okay, we'll fix the matter on 16th.
Yes.
And see how it goes.
Let's see what it is.
Okay, Your Lordship. Leave you, Lordship.
Miss Leonard Counsel appearing on behalf of the petitioner. So one week common order has submitted that since this matter is a very long pending matter, the concerned authorities in the government would require some more time to examine the matter and to come to a final decision as far as the process of negotiation and settlement of the matter is concerned. Though, as admitted by Mr. T.T. Dingdo, London Senior Counsel for the appearing for Respondent 1, the matter has processed considerably, and perhaps some time may be allowed for the parties to be informed of the decision of the government. On consideration of the submission made, though this court is reminded that the matter is that even this process of settlement and negotiation has taken a long time to be settled, to be finalized, be that as it may. On prayer made, matter is adjourned for the day. As agreed to by the parties, this is matter on 16th. The relevant report is to be filed within such date.
Leave you, Lodge.
Item number 3.
Please, Your Honor. Please, Your Lordship. Lordship, this matter can be taken up the end of board, Lordship. The Carnatic Council, Mr. KP, is still available here.
No, we can start.
Hello.
We can have it next week, my lord, because this matter was already heard earlier. And given the fact that we are very...
That's exactly the point. See, if the matter is heard, the court has forgotten what has been submitted.
True, my lord, true. We can have it tomorrow otherwise, my lord, subject to the convenience of this honorable court. Since the opposite side is not there, my lord, we had already finished our argument.
Okay. So they are to...
Yes. We can have it tomorrow, my lord, otherwise.
We'll have it next week.
Next week, ma'am.
Mr. on remade by Mr. H. Karwalang seeking accommodation on the ground that the Leonard conducting government advocate is not present in court today. The matter not be objected to by Mr. S. Thawan and counsel for the petitioner. Matter is adjourned. This is the same after 1 week. Same order.
Oblige.
Item number 6.
May it please your lordship. Lordship, on the last occasion it was informed to the court, to this honorable court, that Same of Sora had passed away. We're trying to get information, lordship, as to who's to substitute him, for us to enable us to file our substitution application before this court, lordship. We require some more time, lordship, in that aspect.
On the what did you say? Since this is a case of death, on the device of the CM.
A new CM has to be appointed.
Any acting CM appointed in his place?
I am not aware, Lordship. Mr. Linda would be in a better.
Then who takes over his functions?
Malad,
Who takes over his functions?
Right now, I think the secretary of the Darbar, Hima, is. Because what has happened, Malad, in Sora, now the present deputy CM has come forward to claim to be appointed as the CM. So that is under consideration.
Okay. So nobody has the authority to appear in this court, in this matter, as of now.
As of now, yes.
Come after vacation, then, your lordship.
Yes. Lordship.
After vacation, then.
We'll take the.
You take steps. Try to find out.
Lordship.
On premade by parties, list this matter to petition.
Apply, your lordship.
Item number 8.
Yes, sir. I can't hear you, Mr. Yubin. You have to unmute yourself, or
my lord, am I audible now?
yes, you are.
So, my lord, I have completed my argument in these two cases, my lord. Item number 8 and item number 9, my lord, arises out of the common judgment, my lord. On our last occasions, the respondents have stated that they sought time. They wanted to file a short synopsis and at the same time forward the argument, my lord. So it's for them to start their argument today, my lord.
8 and 9.
Yes, my lord. 8 and 9 is a common judgment, my lord. And the accused are also brothers, my lord. They are siblings.
Okay. Oh, is that that
parking
lot matter?
Parking lot matter.
Yes, my lord. That's a matter.
So, Mr.
Yes.
Just a moment. Please. Please start.
My lord. May please your lordship. My lordship will recall in this case the appellant had taken some specific ground of challenge of the judgment of my lord sentencing, judgment of conviction and sentencing, my lord. One of the plea raised was, my lord, that TIP was being conducted, my lord, time and again. That was the exact stand taken by the appellant. TIP was being conducted time and again to the extent until it was something had come up in favorable to the prosecution. That was the. Secondly, my lord, that the magistrate in whose presence this TIP was conducted was never examined as witness. Those were the major two grounds, my lord, that was pointed out by my learned friend. First, I'll take up, my lord, Lewis Dordong. That is item 8. Now, my lord, here in this case, my lord, the appellant herein, my lord, was convicted under section 304 part 2 for 5 years imprisonment, and in the present case there are 2 eyewitnesses, my lord. So another plea raised by my friend was one of the eyewitness is a brother of the victim, my lord. So therefore it was further stated that he is a interested witness, my lord. Now coming to the, my lord, evidence. My lord, from the entire evidence and based on the submission of my learned friend, my lord, there is no dispute that late Rigid Kurklang had died at civil hospital on 23/2011. So his death in civil hospital is not disputed, my lord. Inquest over the dead body was conducted by PW12, my lord. And the IO my lord, the IO had conducted inquest on the body and had also found some injury mark on the dead body, my lord. Now let me come to, my lord, the evidence of PW1. It is at page 56 and if I may read, my lord.
Page 26.
Page 56. 56.
Yes.
I know about this case. It was Sunday, Holy Festival, in the year 2011. The younger brother of the deceased called up his own brother, who was also with me at that time. After that, we went to the spot. The incident had already taken place, and 4 or 5 people came to us and started assaulting both the brothers of the deceased. But they did not do anything to me. I can identify only 1 out of the 4 or 5 people who had beaten up the brothers of the deceased on that day, and the accused is present in the court dock today. The witness has pointed at Louis Dordon. Now, my lord, in the chief, he says that he is a friend of the deceased.
Yes.
And at that relevant time, my lord, at the time of occurrence, the deceased and this PW1 were at a different location. And he witnessed that the deceased received a call, phone call, from his brother from the taxi stand. And both PW1 and the deceased went to the place of occurrence, and there what he witnessed was that 4 or 5 people, they came and started attacking the deceased and his brother, my lord. And he further goes to say, my lord, this is very important. He goes to say that I cannot identify all of them, but one of them I can identify. And he is standing in the dock today. And he pointed at the present appellant, my lord, Louis Dordon. Now, what is the position of law, my lord? What my learned friend had stated that even if it is taken, assuming but not considering, my lord, that TIP was not conducted properly. Now, what is the difference between evidentiary value of TIP conducted and the court identification, my lord? TIP is, my lord, whatever the identification, the report comes, my lord, it only has a corroborative value, my lord. In evidence, it is corroborative, it has got corroborative value. But, my lord, identifying in the dock, in the court, the PW1 is under oath, whereas during TIP he is not under oath. Meaning thereby, my lord, under the Evidence Act, when a person is identified in the dock, the witness is under the oath, therefore it becomes a substantive evidence, my lord. Why I say that, my lord? My friend had taken the stand that, I'll come to that later on, that so assuming that TIP was not conducted properly, even that be so, my lord, the identification in the court stands as a substantive evidence. So in the cross also it has come the same way. It is a fact that in the year 2011, there were many people celebrating Holi. When the deceased brother called up his elder brother by telephone call, we were both in the marketplace. It is a fact that I was not present at the time when there was a fight at the parking lot. It is a fact that the deceased is my friend and the deceased during his lifetime is a member of the KSU. It is a fact that both the deceased and his brother were drunk at the time of occurrence. It is a fact that I am not working in the parking lot for collecting money. It is a fact that during the fight they were running here and there, so I cannot identify the other people, but I can identify only one. It is a fact that the police station is nearer, but I could not inform because I was in shock due to the incident. It is a fact that the deceased was still alive when the police carried him to the civil hospital. It is a fact that when the body of the deceased was carried out to the hospital, I did not accompany him. The fight has occurred due to heated quarreling about parking fees, and I do not know what is the parking fee. It is a fact that I have deposited. It is not a fact that I have deposited falsely before this court. So, the identifying in the dock, my lord, and the fact that 4 or 5 people had attacked the deceased and the brother is not demolished or contradicted during the crossing. That also is established, my lord. Now we'll come to, my lord, the...
See, Mr. Guru,
My lord.
he said that it is the fact that I was not present
Yes.
at that time when there was a fight. So he wasn't
Because,
present.
my lord, if I may clarify, my lord, there are two parts of the fight. Initially, there is a fight between the victim's brother and these people, my lord. So he is outnumbered. That is the first part of the fight. Thereafter, he calls his brother for help. So the brothers, they goes there, and then that is the second part of the fight, my lord. So meaning that it is a fact that I was not present at the time when there was a fight at the parking lot. It is a fact that in the year 2011 there were many people celebrating Holi. When the deceased brother called up his elder brother by telephone call, we both were in the market. So at that point of time they were in the market. So that means he has further stated that after reaching there, 4 or 5 people came and attacked both the brother. So this is second part of the fight, my lord, after reaching the place of occurrence. So when he...
But this, you see, this happening of two incidents. First, in a parking lot, and second, we don't know where.
In the parking lot itself.
So the first time and the second time, was it confirmed by some other witnesses?
Well, it is there, my lord. I'm coming to this. This statement of PW1 is corroborated everywhere. So he is an eyewitness, my lord, firstly. Lordship will come to page 68. That is the evidence of PW9, who is also a eyewitness, my lord.
Yes.
If I may read. Second paragraph, honored. On 28th March 2011, around 2:30 p.m., while I was collecting the parking fees at Anjali parking lot, I saw 2 boys sitting in a local taxi consuming beer. I asked for parking fee from them, but they refused to give any. Since these 2 boys were refusing to give the parking fee, I called my brother, late Rijit Kurklang. After some time, my deceased brother came to the spot, and we had a quarrel with these 2 persons who were not paying the parking fee. And after some time, both these persons left the place, leaving the local taxi at the spot. Later on, after some time, 2 persons came back against along with other people who were armed with hammer, iron rod, dagger, and assaulted us, and out of fear I managed to flee away from the scene. But these people continued to assault my elder brother, and after assaulting him, they fled away from the place. After I have fled away from the place, I went straight home and informed the relative, and later on we were informed that the police had reached the spot and saw my brother, who was badly injured, and took him to civil hospital for medical treatment. But unfortunately, later on, he succumbed to his injuries on the same day. Later on, we received a phone call from our friend who were working as parking lot attendee, and they told us that my injured brother has been shifted to civil hospital Shillong by the police. On receiving the said information, I along with my relative immediately rushed to civil hospital Shillong, and we reached civil hospital Shillong. He was bandaged and was conscious, but later 10 to 20 minutes he succumbed to his injuries. Later on, I had lodged FIR to the police at Cantonment Beat House. The FIR was written by the then in charge so and so, being narrated by me, and after being satisfied, I put my signature on the FIR is exhibited. I also remember that I was also asked to identify the accused person, and identification was conducted at the district jail East Khasil Shillong, and the same was conducted in presence of one magistrate. In the said test identification parade conducted at the jail, I was able to identify both the accused person and these two persons were also present in the court today. Witness pointed to both the accused. So, my lord, here he has stated that he had identified them, both of these accused person in the jail during TIP and also in the court document. Exhibit 6 is the identification of suspect so and so. I do not remember whether my statement was recorded by any magistrate since it has been so long. Cross-examination. I had drafted the FIR. I went alone to the police to lodge the FIR. I am working as a parking attendee on the day the incident had occurred, and at that time we charged ₹30 for a parking vehicle. On the day of the incident, I had asked the parking fees from the person who is also present today in the court since he was sitting in the vehicle. There were also another person whose name I do not know. I do not know whether Kamis Dodong was a passenger or a driver, but I was sitting inside the vehicle. But he was sitting inside the vehicle. Suggestion. Counsel suggested that as per the statement of Sri so-and-so, so-and-so during his cross-examination that you and your deceased brother were drunk. Answer. I do not agree to the said statement since I and my brother were not drunk on the day of the incident. It is a fact that there were many people who had assaulted me and my brother, but I also like to state that clearly the two accused persons who are present today in the courtroom. At the time of incident, my older brother was at Foreign Market, Bada Bazaar, and I went to call him from there. It is a fact that I have stated today is what I have stated. So, my lord, from what has been narrated by PW1, the eyewitness, my lord, that he was with the deceased at a different place when they received the call, my lord. So this has been established here during the cross-examination that they were in the Foreign Market. The parking lot and Foreign Market is at a distance, my lord. So it is established that PW9, the eyewitness, had called his brother, and they had come, and thereafter it is also corroborated that both the statement corroborates about the assault by 4 or 5 people, and also he also has identified both the accused person, and the identification of the present accused by PW1 is also corroborated by this, my lord. So nothing contradicting, no contradiction has been made out during the cross-examination, my lord. Now, my lord, PW5, who had conducted the post-mortem report, it is at page 63, my lord. If I may read, my lord.
Yes.
I joined the medical profession on 18th January 1986. During 2011, I was posted as Senior Health Officer in the post-mortem unit office of the District Medical Health Officer, East Kharsil District, Shillong. In this case, I had conducted the post-mortem on the body of late Rijit Kurkalang, 30 years old male, son of Sri so-and-so, so-and-so. The body was brought to the hospital at 6:30 p.m. and morgue on 23/2011 at 7 p.m. and examination was conducted on 21/3/2011 at 12:10 p.m. The body was identified in the morgue. By number SI so and so, Cantonment Bit House. Number 2, Babijay Kurklang, brother of the deceased. Number 3, Jean Unconry, stepfather, and so and so, so and so. The body was in rigor mortis, height so and so, so and so, so and so. Wounds on the body. There was a bruise on the right eye. There was a punctured stab injury, wound 2.2 into 0.8 centimeter on the neck. 12 centimeter from the neck midline below the scapula, and there is another stab injury 4 into 1 centimeter by 4.2 centimeter above the left nipple with bruise running around the wound. Deep abrasion lateral side of the knee 3 into 5.1 centimeter and another injury abrasion 2.1 centimeter below the knee laterally and another injury laceration 2.5 into 0.5 centimeter leave partial vision. The wound is already been stitched. Another injury laceration 1 into 0.2 centimeter right side cheek of the nostril. Now why I am pointing to this, my lord? Kindly look at the nature of the injury, my lord. One is there was a punctured stave injury wound 2.2 into 8, 0.8 centimeter on the back, 12 centimeter from the neckline, midline below the scapula, and there is another stave injury 4 into 1 centimeter, 4 into 4.2 centimeter above the left nipple. Now, my lord, left nipple. So, meaning thereby, my lord, he was attacked in the most vital area of the body, left side of the chest, my lord. That is the heart, my lord. Then, there is a punctured injury, 2.2, 0.8 centimeter on the back. Whether this is back or neck, my lord, we have to go to the original. Be that as it may, my lord. So the nature of injuries, my lord,
Yes.
is multiple. Firstly, my lord, it is not a singular attack, my lord. Multiple injuries and in vital areas of the body, which points to the very intention of the assailant to do away with the person. Had it been in other non-vital area, things would have been different, my lord. Cross. I cannot say how many hours the deceased died, but the postmortem was conducted within 36 hours of his death. I could not say whether there is any sample of alcohol in the victim's body. The penetrating injuries in the chest may have been caused by a sharp weapon. On the side of the head, the injuries were caused by some blunt weapon. It is a case of unnatural death. So, my lord, in the cross-examination, the doctor who conducted the post-mortem has clearly stated that the injuries on the chest is caused by sharp weapon, and on the side of the head, injuries was caused by blunt weapon. So attack was on the vital areas of the body, the head and the chest, my lord. It is a case of unnatural death. So, my lord, here the fight that took place between the accused persons here and the deceased and PW number 9, my lord, is clearly established, which is corroborated by the PW1, who is also an eyewitness, and the nature of injuries, inquest being conducted by PW12, the IO, had found that there were injuries marked on the body of the victim. So PW here, PW7 has clearly stated that the nature of injuries and it was on the vital areas of the body, on the head and on the left side of the nipple. So, and the cause of the death is unnatural death, my lord. So, my lord, here the fighting that took place is clearly established by PW1 and PW9, who are the two eyewitnesses. Secondly, the death of the victim in the hospital is not disputed, and the nature of injuries clearly shows that it was on the vital areas and fatal attack, my lord, indicating the intention of the accused person.
Yes.
Now, my lord, here the main grounds taken by the appellant herein is that number one, that TIP was not conducted properly and it was conducted multiple of times. I'll come to that first, my lord. TIP was conducted only 2 times, my lord. That is my stand. Kindly come to page 150, my lord. What had happened, TIP is usually, my lord, conducted once.
Okay.
But in the present case, it had to be done in 2 occasions, my lord. Why? Because the present appellant was absconding, my lord.
Okay.
Which is why TIP of the other appellant had to be carried out first. Kindly come to page 150, my lord. There are 97, my lord.
Yes.
With regard to the identification of the accused person, it is established that the accused Commerce Dong and accused Louis Dong were present on the day of the incident and assaulted the accused deceased and PW9. From the evidence of PW12, it is found that during the course of his investigation, the test identification parade was conducted firstly on 7/4/2011, where PW9 identified accused Commerce Dong, and in the second TIP conducted on 26/8/2011 after accused Dong surrendered. He was absconding, my lord, and he surrendered subsequently. Then the second TIP was conducted, my lord, surrendered.
Okay.
PW1 identified accused Louis Dong during recording of their evidence before. So, my lord, here I have relied on certain judgment. I'll provide it, my lord. That the only, my lord, defect in the TIP I can see that is that the magistrate was not, my lord, examined as PW. So in that event, my stand is that, my lord, since as I had submitted earlier, the identification was done in the TIP also and in the court doc, my lord. Now the evidentiary value of the two identification, my lord, the identification in the courtroom has got evidentiary value, my lord, and not the TIP. TIP is corroborative.
Yes.
So that is establishment. Second stand of the
Whether there is TIP or not is not so important.
Had it been a case where there was no court identification, my lord, then we have only one evidence, that is the TIP. But here there are two identifications in the court as well as in the this thing, my lord, jail. Secondly, my lord, my friend had pointed out that there was no weapons were recovered, my lord. Now, my lord, there are a number of Supreme Court judgments, my lord, in presence of ocular eyewitnesses, my lord, that non-recovery of weapon, my lord, bears no significance, my lord, if the ocular evidence and the version is, my lord, inspires confidence, my lord. So here PW1 and PW9, my lord, they are eyewitnesses, and that apart, my lord, they corroborate each other, and their version is further fortified by the, my lord, inquest report as well as the post-mortem report, my lord. So in view thereof, my lord, the fight that took place, the attack that was witnessed by PW1 and PW9, my lord,
yes,
the eyewitnesses, my lord, stands, my lord, it stands proved, my lord. There is no contradictions or demolitions in the cross-examination, my lord. Now, non-recovery of, my lord, weapon, my lord, in view of the fact that there are eyewitnesses, there are ocular evidence, there inspires confidence for the fact that they not only corroborate each other, my lord, they are also further corroborated by the evidence of the IO, inquest report, and the post-mortem report, my lord. Now, my lord, The accused was, my lord, the appellant was examined under 313. If 313, my lord, it is at page 313.
Where's the 313?
I don't. In the index.
Index is not there.
I could not find, my lord. Supplementary. They have filed a supplementary, my lord. My lord, as to 313, my lord, this is the most vital stage, my lord, where the appellant gets an opportunity to, my lord, explain against, take a defense against all the evidence collected during the trial that appears to be against him, my lord. Kindly look at the nature in which he has answered the questions, my lord. Number one is, I deny the same and
What is the?
PW1 Sylvester Conceit in his evidence has deposed that I know about this case. It was Sunday, Holy Festival in the year 2011. He, younger brother of the deceased, called upon his own brother who was also with me at that time. After that, we went to the spot, the incident that had already taken place, and 4 to 5 people came to us and started assaulting both the brothers of the deceased. But they did not do anything to me. I can identify only 1 out of the 4 or 5 people who had beaten up the brother of the deceased on that day, and the accused is present in the court. Brother, and he had also identified and pointed towards you as one of the person who had assaulted the victim and his brother. I deny the same and stated that he might have been mistaken. PW3 so and so, in her cross-examination by the police, had stated that the mobile phone seized by the police from her possession was handed over to you by you. What do you have to say? Denied. PW9 Shri so and so in his evidence had deposed that after the 2 persons had left after quarreling, this person came back along with other armed with a hammer, iron rod, dagger, and assaulted them. And he was able to flee from the scene, but his brother was beaten and assaulted, and later this person fled away from the place. What do you have to say? Denied. In the said identification parade conducted at the jail, I was able to identify both the accused person and these 2 persons were also present in the courtroom today. Witness pointed to both the accused person who are standing in the courtroom today. What do you have to say to the statement? I said that he might have been mistaken because I have not assaulted anybody. PW12 Sri so and so in his evidence has deposed that during the course of investigation, accused Louis Dodong, in compliance with the order passed by the district council, had appeared before him on 6/4/2011, and he had seized 1 mobile phone and had also served the notice to the appear to TIP to be conducted at district jail Shillong, but you were found absent and the same could not be conducted. What do you have to say to this statement? I admit that I was served with a notice to appear for the TIP to be conducted on so and so at district jail, and I did not went to the district jail for TIP that day since I was not well, but I had informed the same through my lawyer. Will you adduce any evidence from side? I do not have any evidence to say. So, my lord, the vital evidence that appeared against him, my lord, there is no explanation, 7 except a simple denial, my lord. So, in a situation like this, my lord, when, my lord, when examined under 313, my lord, the accused does not, my lord, exercise his right and gives any explanation is forthcoming, my lord, and the answer is yes and no, my lord, then that itself becomes a missing link in the chain of evidence, my lord. I've got judgment on that, my lord. So in view thereof, my lord, the first stand taken by my friend about the TIP, my lord, that I have already argued. Secondly, non-recovery of weapon, my lord, that also I have argued, my lord. That apart, my lord, the PW1 and PW9, they are the eyewitnesses. Ocular evidence was forwarded and they corroborate each other. That apart, they are backed and fortified by inquest report as well as the post-mortem report, my lord. And my lord, so the learned trial court below had rightly sentenced, rather in the lighter side, my lord, under section 304 part 2, my lord, 5 years was, my lord, for imprisonment. So therefore, my lord, I don't see, my lord, there is any wrong or illegality in the order passed, my lord. So I respectfully submit, my lord, it calls for no interference, my lord. So my lord, I have relied on I prepared my written argument, my lord. I have also forwarded to the my lord, I believe. Huh? There. I have, my lord, quoted the, my lord, relevant paragraph and the judgment, my lord.
Where?
So I'll close my argument.
Where is your?
Is there, my lord, the
Yeah, your court, please.
relevant paragraph and the citation, my lord. And I may be further allowed to, my lord, put forward additional written argument and some judgments, my lord. You find your written argument?
My lord, if my lord, sir, my lord, am I audible?
Yes, yes. Mr.
My lord, may I just
just a moment. You have submitted this argument on criminal P number 60.
My lord, that will cover both, my lord, because it's very similar.
You have written yes, 59 and 60.
Yes.
My lord, may I take 1 minute of a very quick rebuttals to what what the respondents have just forwarded, my lord. Number one thing is, my lord, regarding the witnesses, the 2-star witnesses that are not reliable at all, my lord, that has not been addressed at all, my lord. Now, what thing is that I said the 2 witnesses, the PW1 and PW9, the Sylvester Kongsit and Babiajan Kurkalang, they are interested witnesses, my lord. The first thing is that. And my lord, if my lord will see the statements which I've pointed out the other day, and also the statements, the evidences that have been read out to my lord today by the prosecution or the respondent side, my lord, there is the statements suffer, number one, from material omissions, my lord. My lord have observed that also. And there's a delay and there's a loss of improvements in that, my lord. FIR says that there's a group of people sitting, and then in the evidence that comes that there are only 2 persons sitting, my lord. And it says that there is a fight going on, and because of the fight, we got scared, we ran away from there, we don't know. And if both these 2 persons have come to rescue somebody who's be getting beaten, why would they run away? They have not never explained this, my lord. And the fact that, my lord, one is a brother and one is the friend, my lord. So both of them become an interested witness, my lord. And also, my lord, these 2-star witnesses have never stated anywhere the specific overt act attributed either to Louis or to commute, my lord. These are very general statements that was given, my lord. They said that there was a running, helter and scatter, there was a group fightings going on, and I can identify it. First, TIP was never conducted properly in accordance with law. The magistrate was never examined. To that effect, my lord, my lord will recollect, I have submitted Umesh Chandra's case, my lord. Umesh Chandra's case, the other day I have read out Umesh Chandra's case, my lord. I have submitted that also, my lord, that is reported in 2021, 17 SEC 616, my lord. And this is very much relevant and to the point, my lord, to the point with regard to TIP and test identification in a courtyard. I don't disagree with the prosecution when they say that a court document identification is completely not admissible in law. I'm not subscribing to, and I'm agreeable to that. But when you, for the first time, when you are identifying somebody whom you were supposed to have seen somewhere else, the TIP should follow first, then your identification, then it becomes a probative value of evidence, my lord. In the absence of that, you cannot say that this is a probative evidence and because of which you can convict somebody, my lord. So, my lord, actually, my lord, as I was just listening, my lord, to the submissions forwarded by prosecutions, my lord, there is nothing actually to rebut, my lord. There is nothing to rebut because the number one thing is that, my lord, of course, somebody died. That's not a disputed fact. And nobody is disputing that somebody died. But who is responsible for that? Who is responsible for this, my lord? So the argument forward was of 302, not of 304, my lord. So therefore, my lord, I humbly pray, my lord, once again, my lord, that there is no evidence, there is nothing to attribute or the overact of both the convicts in this case, my lord. And I would humbly pray, my lord, based on the Umesh Chandra's case and the TIP being convicted or TIP being conducted, my lord, not in accordance with law, and also the star witnesses being interested witnesses, and there's nothing that comes out, my lord, any incriminating comings out against the overt act, specific overt act of these two the convict, my lord. I would humbly pray, my lord, to set aside the impugned judgment and order and set them free, my lord. That is all I have to pray, my lord. I raise my arguments here, my lord.
What about the other case, 60?
My lord, I'll rely on the same thing because
covered.
So in the meantime, my lord,
Have you filed your written argument, Mr. Yubin?
No.
You have not filed.
I have not filed, my lord. I can file. I'll be traveling, my lord. So by Monday, my lord, I can give a short synopsis, my lord.
My lord, in the meantime, it may be kept open for me also to file additional certain vital points.
You file your written argument and give copy to him. Then you can respond to that.
My lord.
Mr. Argun Leonard GA for the prosecution, who has concluded his hearing on premier by parties to file written argument. Matter is now posted after 1 week.
Deeply obliged.
My lord, obliged.
To the court, sir, that paper that notice.
You are done for today?
Yes, just one matter.